Much. Thank you for inviting me. Um, okay, so my tongue-in-cheek title, of course, I'm sure got some of you thinking, well, what is this guy going to say? The abstract doesn't say much, although it announces a conversation about the idea of a whole Sharia or a wholesome Sharia. I think it's a phantom and I want to make fun of it. But that wouldn't be interesting by itself. So what I want to do is take you actually into the realms of different legal systems first, so that we can imagine this issue of a law that covers everything. It's not only a medieval Muslim jurist who would say human actions fall under a spectrum or within a spectrum of either 5 or 7 possibilities, where in one extreme of extremely desirable, we would have an obligation. And on the other extreme, extremely undesirable, we'll have a prohibition, and then grades in between. It's not only a medieval jurist. Actually, if we credit, say, Muhammad al-Hasan al-Shaybani or Shafi'i with this kind of understanding around the 8th century, they were pretty late. They were about 6 centuries after Gaius, who gave us one of the early textbooks that we have, and he would say that things in the world, some of them are divine and some of them are human, and this division covers everything. Right? Res sacrae, res sanctae, res religiosus. These are everything: the temples, the walls of the city, and the burial places. And the law covers all these, in addition to the partnerships between me and you, and the property that you or I might hold. Such that we reach that point where Accursius, a man from a commune, the commune of Imprunita, near Florence, who ended up being one of the big contributors to the reputation of Bologna Law School, 13th century man, would say that law covers everything. There is no such a thing as knowledge that is outside of the law. He would write that in his gloss on the digest of Justinian. This is an image of where he and his son are buried in Bologna. So to make this into an image, just for people to think, if the law covers a certain circle, if you peel it, you find life. There is no area outside. This is the theoretical understanding of it. Now, of course, if you dig into any of these assumptions about law covering every aspect of life, you'll find a context, and you'll find, for example, in the Roman case, there's a lot to say. It's not just the issue of, in principle, that things in the world are covered by these classifications, but also an understanding that, well, certain laws are definitely local. There are laws that pertain to the city of Rome. But then there are laws that are shared between Rome and other cities, the Ius Gentium, right? The law of the nations. Well, they're similar in certain ways and they're different in other ways. Then there's the natural law, which govern not only me and you, despite our different ethnicities, but also the two of us and the kangaroos and even the plant kingdom. So there are laws at different level, and if you insist on interpreting law this way, you can find a way. When Accursius talks about the law covering everything, he quotes Ulpian. This is a 3rd century jurist whose work accounts for about 1/3 of the digest of Justinian, and Ulpian is one of the people who talk about this division of the knowledge of law covers everything, in theory. If you know something about Jewish law, you may have heard about a distinction between halakha and agadah. Agadah it comes from a term, a root that means to tell or to narrate. So it has the stories. The agadah has the stories. People who know Hebrew or Aramaic, it will look like this. In the Hebrew or in Aramaic, it will be like this. But there is also the halakha, right? The law proper. Now, the halakha is things that you have to do and things that you don't have to do. Ta'aseh wa lo ta'aseh, right? But there is an ongoing discussion as to whether these are separable. How can you separate the agadah from the halakha if really without these stories you won't understand the details of the law? So in a way, they give the context, and the Agadah are not just stories. They have a lot of moral exhortations and so on. So you can take this. This is not the law that is an abstract, non-subjective rule imposed by a state and associated with a sanction. Right? This is our modern sense of the law. This is something bigger. It would have laws of rituals, for example. It would have dietary laws. The modern law in the common law tradition, history textbooks will tell you, well, it arises before it was a system. It's a series of remedies for wrongs. So you have very modest, very unambitious. You have to make a mistake for the state to pay attention. And then it would punish you, but not reward you necessarily. Right? These laws reward. They say if you do the right thing, there is a reward. So this general law, this extensive law, is what I want to examine today. Is it real? Is there such a thing really as one legal system that at least in theory can cover all human actions, or can cover all objects in the world, or can give us, again, theoretically, and if it exists today, what it would look like. Now, my sense is that today, just like Desmond said, I agree that we are in a moment that is, even within every nation, is post-national. Even within every strong law, we have multiple laws. We have transnational moments and ideas and practices within every nation. And I want to make my case by 3 stories from the American legal system and one from a particular case where the International Committee of the Red Cross, which is involved now in dealing with dead bodies and all kinds of consequences for legal regimes that lived, for example, in Afghanistan and Syria and Iraq, where the nation state is pretty weak, right? And gradually simply disappeared. And what you get from the Red Cross, and especially the forensics division, are questions about what would Islamic law say about dealing with a certain body, with the body of a martyr, or washing a body of the adult. Can men wash a woman? Can a woman wash as a man? Are there exceptions for husband and wife, and so on? And questions about body parts and things that you wouldn't imagine, well, why should we care? Of course, the forensic division does care, because that's what they want to deal with. They want to afford dignity, they want to identify bodies, and they want to connect them. In the 3 cases that I'll mention in the case of American law, you'll see how the judges are scrambling to know what Islamic law would say. They know at the end that they have a different assignment. They have to fit this knowledge of Islamic law into another scheme. So let's begin. First story. The year is 2010, and we are in a meat packaging factory unit in Ardens Hill, Minnesota. 22 Somali workers who love their job, the company loved them, started to have suspicion that the company doesn't care to accommodate their religious beliefs. Now, backing up a little bit, we have something in the United States called the Civil Rights Act, 1964, very unlikely coming under President Johnson, but there's a long story for that, provided us with some basic concepts that we live by today. Can't discriminate based on ethnic origin. That's in Title VI. Can't discriminate based on gender or sexual orientation. That's in Title IX. And the one I'm interested in is Title VII. Title VII says you can't discriminate based on religion. So what would that mean, discriminating based on religion in practice? It would mean that if these 22 Somali workers can't do their prayers and are led to believe that they either keep their job or do the prayers, then there's something wrong. They're not accommodated sufficiently. Well, how did it happen? They were accommodated at first and for a long time. They worked for a long time for the same company, but it was summer. And in the summer, the daily prayers don't fall on a very short spectrum. So state law would say, give these people on a shift that is between 8 and 10 hours. Give them 45 minutes, 55 minutes. That's a long enough time. If you break that into 2 breaks, people will be able to do their prayers And you have 5 prayers every day. One about an hour and a half before sunrise. That's the dawn prayer. You have a prayer at noon, and one between noon and sunset. Call it the afternoon or the twilight prayer. You have the sunset prayer, and you have another one that's also about an hour and a half after the sun sets. Now, the tradition also had it that you can combine prayers 2 with 3 and 4 with 5. You can't combine number 1, the dawn prayer, with any prayer. So if you miss the window, you miss it, and you just do it later, and it would be fewer points with God. But you can combine 2 with 3, you can combine 4 with 5, and the question is, what conditions allow you to enjoy this license? The jurists disagreed. In Shafi'i law, they have this long list of reasons, but it is a finite list. Right? So you can't just do it whenever you need it. But there are many reasons, like, if you have a guest, you can't just keep interrupting your conversation with the guest. You might want to combine. If you are in the mosque and it is raining outside, you could combine so that you can go home and that's it, call it a day. Do the sunset prayer, for example, with the last prayer. Because if you walk and then come back, and, the clothes are going to be wet and maybe it's muddy and so on. But realize this is, again, it's a finite list of reasons to combine the prayers. So you could be a Shafi'i, which is what these Somalis claim, and say, well, it's not one of the 14, 15 reasons that you work in a meat packaging plant. You have to go to Hanbali law, which says you combine whenever you need. But that's the most lenient one. And they take it from a text because Muhammad, the Prophet's companion and cousin, Ibn Abbas, said the Prophet actually combined for different reasons, and he said that has to do with removing hardship. It's not for a specific reason. It's not for traveling. The majority of Muslims would say you combine when you travel, but that's just one reason. So he said, Ibn Abbas said, you can combine when you need it. Hanbali said, well, why make up a rule? Here is the rule. But the Somalis, again, reasonably could say, that's not our law. We don't live like that. We don't combine because we work. Well, there is precedent, once these plants and machine sort of production existed in the Muslim world back in the 1940s. Abdurrahman al-Ghaziri said, you could now combine for that reason. This is a good license to take in this particular case. Because, you can't talk to a machine. And if the number, meaning to tell the machine that, you stop now, or the number falls below a certain threshold and you can't really run the machine, you can't simply stop the work because you don't have the right decorum to run the machine. Abdurrahman al-Ghaziri said that. Qaradawi also gave the same fatwa multiple times. In fact, Qaradawi got really irritated when he realized that people take prayer breaks and make them very long. So he ended up giving a fatwa saying that it has to be within 5 to 10 minutes, because that's really what it takes to do the prayer. If you make it 20 or 25 minutes, you're doing something else. Anyway, it's not a new question. The question of license, it's not a new question, but two experts disagreed about this particular case, and the court was very happy to learn about the license, that it existed at all, and that there was a debate about it. Islamic law here solved the problem for the American judge. The American judge really was in despair, of course, after the first expert said there's no license. Because the first expert said, of course you can imagine, he's the one who wrote for the 22 workers. He said, well, we have a license, but you really use it. It's funny how he understood it. He said, you use it in war. That's when you combine. So he even had a narrower understanding of it than any of the people in the high tradition. Well, the Hanafi tradition has a weird, narrow understanding of it too. They'd apply combining only in pilgrimage. But that's really pretty much a dismissed view that people don't use. Not because Hanafi law is not a very high tradition, but in this particular case, they just didn't have enough understanding of when the Prophet did it and how and so on. But anyway, this expert had even a more kind of innovative view of it. Now, the other expert was yours truly. I ended up writing the whole story and how people disagreed about it. I was not attached to it either way, but if the license exists, you could use it. So Islamic law here was, again, relief for the judge. Maybe it served the purposes of the company, But we ended up, in this particular case, with a collaboration, a cooperation, even though it started as a competition between American law and Islamic law. It started as a competition because American law wants to say, well, I'll accommodate your religion, but look, don't put me in muddy land. Because when I accommodate you and say, take the 45 minutes and break them into 3 breaks, reconfigure break time. Well, you know, the next guy who's not a Muslim, who's going to be a Sikh, for example, would say, well, I can't wear hard hats because, you know, I need to use my turban. And, you know, maybe a Jewish guy or a Catholic guy would ask a different question. You can accommodate religion, yes, but not all the way. And you would like to believe that the Civil Rights Act doesn't create the conditions that make accommodating religion impossible. Just like also some, if you're dealing with government, some understandings of the First Amendment that could be just very hard to see as viable in the long term. This is one story. Okay, so here, I want to leave you with one thought. Islamic law and American law could compete, but could also cooperate. Islamic law actually came to the rescue of American law so that it continues to believe that it can accommodate its religious minorities. Even though it really, of course, whoever wrote that law and whoever even wrote the First Amendment could not have imagined all the situations that arose in the subsequent generations. We're still trying, we're struggling. Hopefully this scheme will be preserved. But it needs a lot of cooperation from other legal systems is what I'm saying. Take the second case. This is an asylum case. Again, the year is 2010 and we're now in California. MMK, that's a woman who comes from Saudi Arabia with her husband and a 1-year-old baby. They came to pursue graduate studies. So a little bit about MMK. She is the child of a Palestinian immigrant to Saudi Arabia who married first a Saudi woman and had a family and then moved to marry somebody else later on. That's MMK's mother. MMK's mother was an 18-year-old woman, a girl from Lebanon, a woman from Lebanon who was sent to marry this man. The Lebanese mother never liked being a Saudi, even though when she was moving, of course, she had all kinds of high expectations that her life would be good. Gradually, she regretted that, and she told her daughter that many times. MMK started to hate also being a Saudi woman. She was very happy to pursue graduate studies in the United States, but it wasn't obvious that, I mean, there was no intention really of staying. But once she and her husband got divorced in 2012 in the LA Saudi consulate, many complications ensued. The next thing would be that she'd rent an apartment with somebody to whom she was not married. Big deal? Yes, big deal, because that is khalwa. Khalwa is the condition of being alone together. Being alone together with an adult male and an adult female share a space that is guarded from gazes, that's a problem. And it's actually punishable by many ways. The last few precedents from the Saudi courts that I looked at, the khalwa cases, in some cases a Filipino worker, for example, had to go to jail 10 months and get administered 39 lashes every month because, of course, they don't want to lash 40 or more. 40 is the punishment for wine imbibing, which is the lowest punishment for a hadd, meaning a specified punishment. So you don't want to hit the 40. So 39 is the lowest one. But the way they understand this is that you can't give 40 or more in one session. So you can end up with 400 lashes. It's just that they have to be with intervals. Anyway, MMK was going to face many difficult problems. Of course, she had to lose the custody of her child. Islamic law assumes that the woman is the presumptive custodian of young kids, and the man is a presumptive custodian of old kids. So women really have a big advantage, but the women have to be of good character. You can't rent a man with somebody you're not married to and expect that sympathy. To make it worse, when MMK was a college student back in 2006, she was caught also with somebody walking at night, and they were not married. This male companion got harassed more than she was, but her record has that instance. She is recorded and registered as somebody who doesn't really respect Islamic law as understood in Saudi Arabia. in theory also, so she could be punished, as I said. In theory, she could be punished even for adultery, which is the death penalty. But you need confession for witnesses, or she has to be pregnant and not married, right? There is no marriage accompanying the pregnancy that could possibly have resulted in it. So if you're 7 months pregnant and you were divorced 3 years ago, then of course that would be a good circumstantial indicator that adultery happened. I mean, she had only many bad options. She didn't have any good options. So she sought asylum. Now, what would American law require from you if you want to get asylum? You have to expect persecution. You have to belong to a group. And then you have to link the persecution to your belonging to the group. What is the group? She's not an ethnic minority or anything like that. She's not a Shia in a Sunni country or anything like that, but she's a woman. And that's a recent development, that actually discriminations against women could be grounds for asylum. Again, Islamic law here, I mean, it sounds very bad here because you have to scare the American court about what Saudi Islamic law would do to that woman for her to get asylum. But it is that competition and cooperation and a lot of education for American judges and lawyers in the process. The third story comes from, it's a consequence of the American invasion of Iraq. You know, in 2003, when the United States invaded Iraq, a lot of people predicted that a lot of good things and a lot of bad things will come out of this. So for example, Iraq could be destroyed. That pretty much happened. But also a lot of Iraqis could come to the United States and become American citizens, and that also happened. So one of these people, AJ, he'll go by AJ for my purposes, became an American citizen, filing many tax returns in the process in the meantime. But there was still the status of a certain property. It's a factory back in Iraq. The status of that factory in terms of was it his property, therefore he owed taxes on it, or was it his father's property, hinged on understanding the Iraqi personal status law, which regulates inheritance and relationships within the family, and some aspects of property law, and a lot of it is really Islamic law made into the general rules that apply in Iraq. So what was going on really was his father didn't want to give up the factory, of course, because nobody gives his property away, even if you believe that your son should inherit you after you die and running the property. You don't want that to happen when you're alive. So the son really, AJ, never owned the factory, but he ran it. The question was, could this father, for example, have put it in a will? And the answer is no. Islamic law would say you can't bequeath to those already designated as inheritors with specific shares. And the son in this particular case wouldn't have been one of the share carriers, but he would have been a male agnate who collect the rest of the inheritance after the first class. So again, if the deceased dies today, we look for 12 classes, 8 females around the deceased, and 4 males. Now, usually you would have only 11, not 12, because one of the males is a husband, one is a wife. You can't have both. So in the case of a male deceased here, you could have a wife, mother, grandmother, all 3 possible sisters, maternal, paternal, and full, daughter, and the son's daughter. These are the 8. And in the case of the male, now again, if this were female, we would have a husband, but in this case we can't have the husband, we have only the father, the grandfather, and the maternal brother. This is a peculiarity in Islamic inheritance law, that if you are the paternal brother or the full brother, you have to wait as a male agnate. You don't collect one of these shares with the initial 12. But you could collect everything if these run out. In this particular case, the deceased would bequeath 1/8 of his inheritance to his wife, and the rest would be divided between the kids, right? So AJ and his brothers and sisters would inherit the rest. There's an interesting peculiarity here that I don't want to talk about a lot, but one of the sisters is dead and her kids are available. So they would take what they call a compulsory will, and they would collect that first. In any case, AJ would have collected something below 20% of the factory's value. And the anomaly or the peculiarity here that looked very mysterious to the American court had to do with these simple situations, what you would expect after the death of AJ's father. Why did he do what he did? Why did AJ not pay the taxes? The answer lies in this complex scheme. Now let's move to the Red Cross, and we're also still in the same decade because the Red Cross started to ask these questions in earnest around 2013, 2014. By 2015, they really decided they wanted to hire a legal expert. Now they have a Sharia expert who used to be a professor at Al-Azhar University, and then even that was not enough. They started to invite different Sharia experts, and they would give you questions like the following. Let me read to you some of the questions, and I got a list of 32 of them. What's the view on the extent of post-mortem examination of the body? External and full examination of the body? Are examiners allowed to unclothe the body? Are there instances where they're not allowed? What are the views on the examiner being of the opposite gender? Can you take photographs of the corpse? What are the views on restoring the body using specific medical techniques or tampering with the body? Now, a lot will depend on whether you call this body a martyr or not, because there is a rule that you don't wash martyrs, you don't pray on them, you don't offer funeral prayer, you just bury them right away. There's a mythology associated with this. The Prophet said that they would just come in the Day of Judgment that way, and their blood would smell like musk. But a lot of jurists said, well, there was a very good reason for him not to wash and offer funeral prayers for a large number, like 300 plus people after the Uhud battle, which took place in 625. That's the first time when Muslims really realized that it's just inconceivable to wash the bodies, bring these bodies from the battle scene. Even though in civil life, that's what you do. You offer everything that you're not offering to the martyr. You wash, you shroud, cover, and then you put for prayer. Even for body parts, right? So if you end up finding a body part, and these happen too, even in civilian life, if you can identify the body, and the old precedents would be like if you have a ring, for example, and they have cases, then you put the body part next to the main body. Would you bury less than half a body? Muhammad ibn Hassan Shaybani, the true founder of Hanafi law, says no. There has to be a head, and there has to be at least half of the body for us to offer the prayers. But if you keep getting these body parts, you bury, yes, but you don't necessarily offer the prayer. Questions also include, what are the perspectives on the time frame for burial of the body? You have to bury quickly, right? But if you're going to examine the body, you can't bury quickly. Are there any specific views on the remnants of the material used for testing? After DNA testing, for example, and you'd apply that, sometimes there's no body at all. The body has decomposed a long time ago. You were dealing with bones and teeth and cranial tests, you're dealing with a skull and so on. What's the view on the clothing, personal belongings? So you find all these things. Could be a watch, it could be something else. Of course, there are precedents for most of these things. What do you do with the sword? What do you do with the clothes that a soldier had? So do you keeping female and male bodies same refrigerated room? Are there any special religious treatments to be taken into consideration if the body is being referred to as a martyr? If there is a need for collective burial, what would the perspective be from Islam on the arrangements of the bodies within the grave and mass graves, questions of putting men and women together? There are answers to most of these questions going back to the tradition, because the wars already provided these situations that look like disaster zones or war zones today. But there is, of course, a side of this that's beyond what a jurist who's dealing with books can do, the social anthropology side, because after the madhab and after all the applications, there are local interpretations of these traditions that are different in Afghanistan, different even in different sides in Afghanistan, different in Syria and Iraq and so on. It depends on who you're talking to. The knowledge of this Islamic law really aided the forensic anthropologists who were trying to do their job, identifying bodies and body parts, and affording dignity to the families of these deceased ones, the dead ones. Of course, there are other sets of questions that I don't want to bother you with, because every question of law arises here. Think about ISIS. ISIS lasted only 3 years. They applied a salad of Iraqi law, Syrian law, and their own kind of law. In fact, really, they applied national law whenever they didn't recognize it as bad. And this is also a subject for another discussion. The things that were Iraqi law and Syrian law just don't look wrong from their point of view. And I'm not sure their scholars are that good or versed in Islamic law, but they decided certain things are important. Now, in the meantime, in these 3 years, people got married, kids were born, rights and responsibilities arose. Yes, after the liberation, a lot of people reconsidered some of these marriages and some of these family ties, but not all of them can be undone. Remember what we said in the morning about time. Time actually is pretty basic in Islamic law. Time is the only difference between a correct or a legitimate revolution and an illegitimate revolution. In the Baghi discussion, when you change the government, if that happened 5 months ago, and you can go back, and it's an illegitimate government that you placed there, you can go back. Yeah, you can rewind time if it is 5 months, but after 10 years, the corruption or the disintegration of the society that arises after the new order was established would be so undesirable that it would be bad to revolt. Time also creates rights in the property area. Possession turns into ownership after time. You can lose your right to litigate also in Hanafi law in particular after a certain time. The Hanafi judge would say that if you never claimed your right to a certain land, after 15 years it's probably not yours. There's going to be a battle of intuitions about memory, and evidence is always flimsy and so on. So time is such an important issue, and yes, ISIS didn't last a long time, but for certain purposes it did last a long time. If you can make a baby, that's a long time. That creates a human being and creates certain ties and creates questions about the custody of that child, for example, after if the parents are around or not around, if one of them is an ISIS fighter, and so on. So the ICRC really hasn't exhausted the possible areas where laws would compete, again, cooperate, and end up creating a new view of how law covers life. But it is on its way. And according to Oren Finnegan, who's the head of the division, the forensics division, he told me that we are now 70% in the Muslim world. Our work, the forensic anthropologists, 70% of our work are disaster zones and war zones in the Muslim world. I have to figure out this Islamic law thing. It helps. It fixes a lot of problems. And it creates, and you would be surprised by how many times the Iraqis and the Syrians there appeal to Islamic law. We don't want to hear about international law. That's what got us screwed, international law. We really want to know about that other side, the religious law that will create stable relationships and things where consent is meaningful, where gradually people will just settle into new situations and so on. So, was Alpian right? And were the classifiers of human action into 5 categories in the Islamic legal tradition right? That law covers every aspect of life. In their mind, it was their law. It was not any law. Maybe the Romans were a little modest when they thought, well, an aggregate of the civil law and the jus gentium and the natural law, yes, covers every natural phenomenon in a way, although they didn't necessarily specify that. They didn't work on this natural law, whether they were Epicureans or Stoic. There is no real theory. They don't have something like the evolution that we started to talk about in the 19th century, where we can think of every living being and then even the idea of life itself as falling within a spectrum. Hanafi jurists also were modest because they said there are 2 abodes in the modern world, in the real world, right? There is an Islam abode, and that's where the government, it's not the population, the government enforces Islamic law. And then a Jew and a Zoroastrian and a Christian living in Kufa, for example, or Baghdad in the 8th century will have to abide by that. So that abode is a place where the jurist can think freely. But how could the jurist prohibit usury in the other abode, in the unbelief abode? What the Muslim jurist thinks is bad is thought of as good or acceptable It's called business. And the Hanafis sometimes went too far in this over the centuries. They started to say, well, you know, these, in the unbelief abodes, weird things happen. People just, you know, the rights and responsibilities are allotted very arbitrarily and so on. But at least they were modest to say that we don't govern the planet, right? We can't. Shafi'i said that we govern the planet, but again, they didn't work this out into a detailed way of what happens, for example, if somebody drinks wine and there are two witnesses, but it isn't the unbelief abode, and this guy comes back. Well, Shafi'i in theory would say, yeah, we'll flog that damn guy because we have the evidence and he was a Muslim, he should have refrained. The Hanafis would never do that, would never, even with the availability of evidence. So there is that modesty, and of course the Jews have a lot of modesty. They have the halakha and they have the Agadah, but they never thought that they could make laws for the world. They were traveling all over the world. They were a very successful minority in different parts of the world. And even when Britain built its own empire, as we can learn from any history of British law, they had to give up what was in theory in their hand in terms of imposing British law. They built the Anglo-Hindu law and the Anglo-Mohammedan laws and so on. So nobody really proposed to govern the whole planet, again, unless we're talking theoretical exercises. But this idea is not dead, and it is there. It's actually in our mind, I have to say. In this new global abode, no matter what we think, no matter what kind of law we have in mind, we are encouraged, and if we are comparatists or comparativists, we hope to think of a way to combine these legal traditions. We know law has a very local side, regional and territorial. It's not like science. So if we end up wanting to do what Thomas Kuhn did in the natural life and physical sciences and make our own kind of more sophisticated way of looking at legal and literary studies through a Kuhnian kind of a view to think about progress, legal progress, and the change in traditions and the mutations and all that, we would be in for a very long discussion, and I guess that's partly what we're doing here. But we're not going to finish. I mean, we're starting and we know we're not going to finish because this simply takes more than erudition. I don't know, maybe it needs a prophet. Maybe it needs somebody who simply understands how different legal traditions relate and would propose a way to think of it globally. Absent that, we're just functioning as academics. We continue to think about the problems that we understand, and if we also consult for law firms or whatever, we give limited advice, and there is really no global view of the law despite all the mechanisms that we have. There is no whole Sharia. There is no world in which a wholesome Sharia applies, just like there is no truth, full truth, by the way, when you swear to tell, in the language of the Victoria Court Services here, the evidence that you present be the truth, the whole truth, and nothing but the truth. It's something you imagine. It's a subjective sense of it. Yes, juror and judge are supposed to work all this into a fuller truth, but that fuller truth will still fall short. It might capture the most important event in a certain case. If we're wondering whether a certain sale occurred or not, we might be able to have a good guess about that. But there is a lot of truth, a lot of social truth that is hiding there that we can't capture. And of course, by the same token, there is a lot that the law cannot cover if it is simply a problem solution mechanism and not an ideal that an academic has. Thank you.